Item number 1, pronouncement of judgment.
Who's there on the screen? In this matter? What have I said? Next time, show cause. Whoever is responsible. As long ago as on 25th November 2019, Reliance Projects and Property Management Solutions Limited had submitted a resolution plan for the acquisition of the first respondent. It was approved by the adjudicating authority, NCLT, on 3rd December 2020 to be effective from 22nd December 2020. The appellant had not submitted any claim for the resolution professional. Its alleged debt now claimed is not included in any statement of debts in the resolution plan approved by NCLT. Neither till date the appellant has taken out any proceedings to include this debt. Learned Advocate General appearing for the appellant very strongly contended that the public announcement or advertisement of the resolution process or any communication of the insolvency resolution professional inviting claims was not received or viewed by his client. There is nothing in the record advancing or substantiating this case. The effect of the decision in Rainbow Papers Limited, as I see it, is that if the resolution plan does not include all the debts, it is invalid. Furthermore, according to the decision in Rainbow, the resolution professional, the committee of creditors and the adjudicating authority have concurrent duties and responsibilities to check up the plan and satisfy itself that inter alia all the debts of the corporate debtors have been included, irrespective of the fact whether the creditor has lodged a claim or any proceedings are taken out. It is true that the decision in Rainbow Papers Limited said that if the resolution plan does not comply with the procedural rules of the court, it would be invalid or void ab initio. If it is so, it has no effect from its inception. In my opinion, unless any contrary order, you bring the draft I gave you. You have made a hodgepodge of this. All this was deleted. You bring the draft. In the facts and circumstances of this case, the said alleged debts of the first respondent to the appellant are not included in the resolution plan as approved by the adjudicating authority NCLT on 3rd December 2020. Therefore, those debts before the effective date of the plan are deemed to have been extinguished. Therefore, I pass an order of injunction restraining the appellant from taking steps or from enforcing his demand notice dated 12 June 2023. Lastly, the question arises as to whether this court can make a declaration with regard to extinguishment of the said debt. Section 60, 61 and 62 provide a judicial remedy, however remote, to the appellant and anyone similarly situated to establish the incomplete nature of the resolution plan and to seek a declaration that the plan as approved is invalid in terms of the Rainbow Papers Limited principle. In such a situation, this court would refrain from exercising its writ jurisdiction to make the declaration the first respondent wants. This appeal is partly allowed by substantially affirming the judgment and order under appeal with the above modifications and observations, the improved notice dated 12 June 2023 set aside without going into subsisting right of the appellant, if any, to challenge the resolution plan. Notice is set aside, yes, but the option under 60, 61 and 60 is there.
Yes, madam.
To seek a declaration, yes, either party can seek a declaration.
Yes,
Which either it is extinguished or you that it is not under the rainbow principle.
Yes, ma'am.
That the rich court will not take a declaration.
Yes, ma'am. That 2nd May of this.
However, remote the possibility, if you succeed, then you will issue a fresh notice.
Yes, my lord.
Number 2,
My lord, number 2 is a matter, my lord, which has been referred by the learned single judge division bench, my lord. But here we are challenging, because what happens, your lordship, in the other matter, my lord, international spirit, there is a challenge to the very policy under which the central bonded warehouse was set up, my lord. Now, during the pendency of the matter, the state has filed an affidavit before the Honorable Court that the state is contemplating to set up another central bonded warehouse, my lord. Now, we challenge that decision of the.
So the writ is to be heard.
It is to be heard, my lord.
And Mr. Justice, thank you, has released the matter.
Release the matter, my lord. What happened when the matter was reserved, my lord, and since the time of inception of the proceeding, certain interim orders were passed, my lord, and the interim order are to continue till today, my lord. That is the observation of the learned single judge. And learned single judge has held that for further continuance of the interim order, we have to.
It is ready for hearing.
It is otherwise, in fact, the matter is heard, my lord. Pleadings were complete, the matter was heard. It was
By his lordship.
by his lordship, it was heard de novo. De novo, my lord.
The matter has to be heard de novo, my lord.
Learned Advocate General, please give a date when you.
Yes, Your Lordship, because this matter, my lord, has some bearing on the other connected matters, my lord. If Your Lordship would recall, in the other connected matters, the challenge is that the state cannot create monopoly in favor of one central bonded warehouse. That is the challenge, my lord. Now, when matter was pending, certain orders were passed in those matters where the observation was made that you look into the issues. We have looked into the issues and we found that we can create additional bonded warehouse to allay the apprehension. We have created the central additional bonded warehouse, my lord. Now, so additional, and for that, policy decision was challenged before the writ court, my lord. Therefore, now this matter will be heard after Your Lordship's decision in the connected matters, my lord, because the main challenge is there whether we have power to create central bonded warehouse.
We have the jurisdiction to hear the connected matter.
Yes, my lord.
This matter is.
If I may allow to intervene, madam, and in the other matter. The first challenge is whether any central bonded warehouse can exist at all. That is Mr. Jishnu Shah's challenge. If Your Lordship, we are of course, and for the state, I mean that matter, we are saying it can be done, there is no difficulty. If theoretically Mr. Shah is right and one bonded warehouse cannot also be created, then the question of the second one will disappear. Your Lordship gets it. So really this first challenge should be heard and the first challenge is to be repaired. I believe the central bond warehouse is supporting us at that one. So it's only when Your Lordship will decide.
This also concerns liquor.
Yes, ma'am.
The same matter. The difference is one more central bonded warehouse has been created, to which there is a challenge. Original challenge was that not even Mr. Shah's challenge was not even one central bonded warehouse can be created.
I know the petitioners there, Mills. The challenge is that it's not only one, it is not one. It cannot be a monopolistic single entity. That is the contention.
I stand correct. That
is the contention there.
The contention, now that has
This is what the state is doing. They're saying that no, we can have one more. That's what the contention in the second matter is.
So they are connected in a sense.
So one after the other we will hear.
But you are already hearing
The spirits matter. United Spirits.
Our only concern, my lord, because since the time we filed the matter before the learned single judge, my lord, we also kindly sees the last order of the learned single judge, my lord. This is dated 30th of April 25.
Yes.
My lord, if I may take the lordship to para 13, 14 and 15 minutes of the last order dated 30th April. But most importantly, para 15, my lord, the learned civil judge said, accordingly, let the records of this writ petition along with this order be placed before the honorable division bench of this court for due consideration. It is further provided that as interim orders are in operation, the petitioner for continuance of the same shall have to make a fresh prayer before the honorable division bench when this matter is taken up for consideration. So, my lord, our case, my lord, lordship kindly permits, I am led by my senior, Mr. Misra is the one, my lord, lordship permits him to submit. Yes, Mr. Misra, please.
My lord, may I please your lordship?
Mr. Mr. We will do this. We are hearing this matter. International Spirits and Wines Association. The other writ will be heard just after that, one after the other.
My lord, I am appearing here also in this petition also, this writ petition also, I am appearing.
Yes, 4:30 of 2024.
4:30.
4:30, WP 4:30 of 2024,
That's right.
Ampolya Central Boundary Warehouse.
Yes, my lord. So, my lord, what I was praying, my lord, since the interim order was in operation for quite some time, my lord, since the time of filing,
We will extend the interim order,
my lord,
and here you are writ,
my lord,
just after Mr. This writ.
so today itself, my lord.
No, one after the other.
One after the other.
Mr.
So,
Gary,
what will happen, my lord, now the state has issued a tender and the last date of the submission of tender is 26th of May, my lord.
So tender process can go on with the second outcome, my lord, because they want to
What will happen, third party rights will be created, my lord.
no third party complication. So there will be no third party right, my lord. If you lordship will see the order, if the order of the learned single judge dated 29th November, my lord. 29th November, the learned single judge has granted since the technical report, because if you lordship will see 29th November 2024 report, my lord. So, my lord, what I was praying, my lord, that
whatever interim order is there is there. We cannot add interim order at this.
and there is, and in, as per us, there is no interim order, my lord.
I will say that there is no interim order. Matter is heard, my lord. Because this will lead to further separation of further country.
All right, interim order, if any, will continue till disposal of the writ petition, if any.
Your lordship,
We are not adding any interim order. And if interim order has to be added, a fresh application has to be made to show change of circumstances.
But the order, as it continues, my lord, that will continue, my lord. That will suffice.
because there is no interim order, my lord. If you lordship will see the event, the learned single judge, while resolving the judgment, did not grant any interim order.
My lord, para 15 is very clear, my lord. The learned single judge has extended the interim order. Lordship till today, my lord. And today you have to make a
Just because there was a prayer before learned single judge when judgment was being pronounced, my lord, and learned single judge said only division bench can exercise the discretion. We will not extend the interim order. And if your lordship will see the order of the learned single date 29th November, it was till next date, and after that, when it was not extended, they moved the application. And then thereafter, it was not further.
As a matter of routine, it should be extended.
It was not, because there was no reason given, my lord. My difficulty is, my lord, I should know the reasons on the basis of which interim order is being given. My case is, my lord, that this is a policy decision to create, and they have not even established their plan.
You have not challenged that interim order.
Because there was no occasion for me to challenge, because it was not extended. When I said that it was not extended, we proceeded with the matter. They moved the matter, and then when judgment was reserved, also the interim order was not given to me. Which order I will challenge? My lord, I put this question on myself. Correct. There was no interim order, and what are we doing?
When did the interim order expire?
Interim order expired on the date of judgment itself. You also will see the date of the last order of the.
But para 15 is so clear, my lord. That interim order is in operation.
10 orders are there extending the interim order. 10 orders are there extending the interim order in the last judgment. Now 15 is there.
And at least I should know the reason why.
Lots of
the interim orders are in operation.
And if you also will see the last order, there is no interim order.
there is no interim order, my lord.
There is no interim order, my lord.
My lord, if I understand correctly,
Was any interim order passed?
One interim order was passed on 29th November, stating that since technical committee has submitted the report, nothing has been done, status quo till next date.
Interim order.
Then the learned single judge said, I will hear the matter finally. We argued the matter in entirety. Then learned, and in between minutes, some interim order was not passed. My friend moved the application for extension. It was extended by one date, and when judgment was reserved, we said no interim order should be extended. On that day also, on the date of the reserved judgment, there is no interim order.
but I don't know.
Because ultimately, single judge, this court has to decide whether there is a fit case for interim order or not. Well, I will show that it's not a case for interim order. And what are we doing as of now? We are only issued advertisement. We are not creating any third party right. We will also injunct subject to outcome, we will also may make it. But they are trying to stall the process, entire process without any basis.
What are you proposing to?
And I have issued advertisement asking for the application to set up additional bonded warehouse. Tender, they will tender notice to them. They will submit the tender, it will be scrutinized. After scrutiny, we will place the report before your lordship. But they want to stall it because they want a kind of, this is the policy under the rules we have established, and we have a right to establish, my lord. Even they have not established balance of convenience, prima facie case, and irreparable loss, my lord. These three parameters have not been at all adverted to and touched by the learned single judge. My lord, where do we go? In the sense that not avoid a contract. The reasons are assigned for interim order. At least we have forum to manage our grounds, my lord. But if the interim order is given without any reason, without any basis, and no interim order is given, my lord, what do we do, my lord? Where do the state go? At least state cannot be rendered remedialess in these matters, my lord. My submission is, my lord, kindly hear us on the interim order. If my friend is asking the interim order, I will satisfy that it's not a fit case for interim order, my lord. It's not a fit case. And we are not, it will not prejudice in any manner.
It's a tender to run bonded warehouses.
Yes, central bonded warehouse. Second bonded warehouse. Only NIT. And under the initial license also, we have
One bonded warehouse.
only initial license also, we said we can set up more bonded warehouse. Rules are also, even their own license says that we can have more bonded warehouse.
This advertisement is for one central and
One additional central bonded warehouse.
My lord,
but the tenders, please hear this order. Yes.
some protection, my lord.
Yes. We have examined the order of the learned single judge dated 30th April 2025 in the writ petition bracket WP within bracket C number 430/2024 bracket closed. As issues are identical, we propose to hear out this writ petition immediately after the writ petition WP bracket C stroke 186 stroke 2021 and WP 2021 along with connected applications appearing in our list today for hearing. We propose to hear out, what is it? All right. And pronounce our judgment. In these matters together. Paragraph, there is a little bit of confusion on perusal of the records whether there is any interim order at all subsisting in WP within bracket C number 430 of 224. Full stop. Learned Advocate General appearing for the respondents submits there is no interim order in force, whereas the contrary is submitted by Dr. Muzika appearing for the writ petitioner. The said order of the learned single judge dated 30th April 2025 provides that quotation, last 4 lines of the order. Paragraph. We are not going into any controversy. Full stop. Taking into account the submissions of the learned Advocate General, we direct that the respondent shall be at liberty to proceed. With consideration of the offers or applications received further to the tender issued inviting the same to set up an additional central bonded warehouse. The respondent shall be at liberty to consider them and select a successful bidder tentatively subject to approval of the court. We make it clear that no agreement shall be executed further to this invitation to tender.
Grateful. Grateful.
Till disposal of the writ or until further order, whichever is earlier.
Grateful.
The tender documents shall be, the tender documents after such consideration shall be kept in a sealed cover to be produced before the court.
Item number 5 and 6.
This is the matter from
Yesterday's matter.
Yes, my lords. My lords, for the convenience of the court, my lords, I have prepared one note, 2-page note, my lords, of the relevant list of dates. My lords,
It's 11. Just having to shut that door, and what is become a little stuffy. If they can just increase the fan speed of the AC or lower the temperature a little down. Yes, please.
yes, my lords. So, my lords, the first important date in the matter is the date of issuance of the tender, which is 4/7/2023. I had indicated, my lords, this aspect even yesterday. So I'll not, my lords, take your lordship to the relevant page. Just your lordships may note that the relevant clause has been quoted herein at clause 4 at page 94, which says clause 4(3) specifically provides that tenders quoting below the estimated cost of work will not be accepted. And it was a contract for the purposes of construction of an indoor stadium. So it is a construction contract, and estimated value we had provided itself because based upon our understanding of what is the amount of cost that will be required in this matter. Specifically provided anything below will not be accepted. My lords, now the crucial aspect is because as far as how the tendering process proceeded, the second most important date, my lords, in this matter is that after the submission of bids, there was the technical bid evaluation stage which had reached in this matter. So that happened, my lords, if your lordship sees point number 2, on 27th of July 2023. And if your lordship kindly sees page 7 of the additional affidavit, which is dated 11th of February 2025, filed by the government. This I request your lordships to take this affidavit, lords, because that is of some relevance. The affidavit.
You see, the learned judge has allowed the writ petition.
Yes.
On the ground of suspicion of a cartel operating.
Yes,
so as to subvert
right.
this tender acceptance process. The basis for the submission being that 4 bidders entered the fray. Now all of them, 1, 2, 3, 4, quoted identical rates,
yes,
which was the bare minimum. Now, unless they were in communication with one another, 1, 2, 3, and 4 different persons could not have tendered for the same rate. So this was the basis for his lordship's suspicion. All right. And why the lowest rate? Because somebody else could not quote any rate lower than that because of the stipulation that it could not be below the reserve price.
Yes,
so any other outsider, let us assume, these facts are not fully, these are only matter of suspicion. They are not proved. In a writ, it cannot be proved. You need evidence from the box to prove all this. Now, this is the suspicion of the learned judge that the 5th person could not enter because he could not bid lower than that. And there was another person who had bid just 1 rupee more.
Yes.
So either these, one of the 4 would get, or the fifth would get. Nobody else would get.
Yes.
Now, ultimately what happened, that 3 out of 4 backed out. Now, when 3 out of 4 backed out, a further suspicion was raised that this was further to a pact, that three back out, therefore the fourth will get it.
Yes, Milord.
And this is a suspicion which the learned single judge has not expressed, but because of that it has entered, at least my mind, that the pact was that all 4 would leave, would back out, and he would get it. But in the end, that pact failed, and 1 out of 4 backed out, and he lost.
Well,
This is it.
I appreciate, my lords, what is falling from your lordship, but kindly seize, my lords, the minutes of the meeting, because that will allay your lordship's
rock
suspicion.
bottom 4 and the 5th just 1 rupee more than that.
Yes, my
So this is it. So cartel and the learned judge has set aside the whole thing.
right.
But what has happened in between is that equity has set in,
Yes.
which means that the successful bidder has completed 30% of the work
Yes.
as submitted.
Right, my lords.
Now what will happen to that?
In my understanding, my lords, in my understanding, the as far as the question of, my lords, fair play in the tendering process is concerned, from the inception itself, as it is clear from the minutes of meeting, is that all the bidders were given sufficient opportunity, my lords. Even at the technical stage, there were certain discrepancies which was found in respect of all the bidders. There were some signatures were missing, some documents were not uploaded. Even the petitioner had not uploaded the documents.
And
as
one
per
more
the
thing, let me complete. There is one decision of the Supreme Court, I think 86 Supreme Court or something, which kind of ascertains the profit margin in these tender contracts as 15%.
Right, my lords.
It says that a contractor usually reasonable profit is 15%. Now the most he could have got, if he got the tender, was 15% of, because he is not making any expenditure
Right.
in terms of cost, etc. Of 15% of 1
the-
crore 78 lakhs or something, which is
2
the
crore, yes, my lords. 87 lakhs.
2 crores, which is about 30 lakhs. Now, right?
Yes, yes.
Now, if he would have got the tender, but there was no 100% guarantee that he would have got the tender.
Right.
So if you put his chances at 50%, he would have got, he would not have got. He might have failed for technical reasons.
Yes.
So half of that you give him and finish it off.
Because in that your lordship, that observation I am mindful of, but your lordship, in this case,
Now
let
you
us
proceed
assume-
with your argument, the court will not make any further observations.
Right, lords. So, my lords, in this case, if your lordship takes the technical committee minutes of 27th July 2023, which is at page 7 of my affidavit of 11th February 2025,
Yes.
and a background to, my lords, this affidavit was your lordship's order of 6th February, where your lordships had noted para 11 of the impugned judgment, and one of the bases on which the impugned judgment was passed was that there was no technical evaluation at all. Apart from the cartelization issue, one of the considerations which impressed the learned single judge was that there was no technical evaluation at all done in this matter. So, in view of that finding of the learned single judge, your lordships had granted us an opportunity to file an affidavit. And in pursuance of that, this affidavit was filed, and the first annexure your lordship sees at page 7 is the minutes of meeting of the technical committee.
And it says, my lords, at the second paragraph, I am reading, at the first instance, the members of the committee was informed that 5 bidders have submitted the original documents in hard copy before so and so, the submission date which is there, and these 5 names are mentioned. Thereafter, my lords, it says that on opening of the e-procurement portal, it was observed that the 5 bidders have uploaded the documents. Upon checking IPO, cost of bid document and earnest money uploaded and submitted by the bidders in presence of bidders' representatives, it was noted that the EMD deposit of Shri Odimar CM Sahib, which is the petitioner, was found that the figure of the amount deposited is indistinct. However, the committee decided to allow the concerned bidder to submit the original receipt of the EMD from the concerned bank for authentication of the EMD made. The tender committee requested the evaluation of the technical bid to be taken up by so and so and put up before a new committee. So the petitioner's bid itself was found to be with certain discrepancies, and opportunity was given to that. Thereafter, Lordship sees page 12. Subsequently, again the technical committee sat for evaluating the technical bids. This is at page 12, the meeting dated 21st August 2023. Here, beloveds, observations of the technical committee are noted. The technical committee, after a thorough scrutinization of the comparative statement, observed the following. And in respect of all the 5 bidders, first is Mr. Mostofar Kharkhongor, Mr. Odimar CM Said, Tabin Varjiri, and Mr. Colin Star Swakmi and Mr. Marbaniang, all the 5 bidders, there were certain discrepancies. And again, the resolution was taken up. Resolution reads, after threadbare discussions, the tender committee has decided that documents which have not been submitted by the tenderers will be sought from the bidders and are to be submitted within 7 days from the dates of issuance of this letter, with an undertaking that the authentication of the documents as uploaded with hard copies submitted, if any. So, all the bidders, including the petitioners, had certain discrepancies, and they were given certain time fairly to everybody to submit the documents so that the technical evaluation can happen properly. This, my lords, is followed up at page 14, which is the final decision on the tender of the tender committee on the technical aspects of the matter, whereby a meeting is held on 6th September 2023, and thereafter, my lords, its notes as point number 7. The bidders submitted the shortfall documents as sought for. Statement on civil work orders average turnover with the original comparative statement and the shortfall documents submitted by the bidders were appraised by the tender committee on the meeting held on 6 September 23. After scrutiny of the members of the tender committee, it was found that all bidders are qualified for the technical bid, and to expedite the process, the tender committee has decided to allow for opening of the financial bid on 8th September 2023. So, a fair opportunity to all the bidders was given as far as the technical stage is concerned, and thereafter, even though irrespective of the fact that what is the financial quotes made by them, the technical committee took a decision that all the members have qualified the technical stage, and on 8th September they decided to open the financial bid, which my lords will find at page 17. At page 17, annexure A4, it's the minutes of meeting of 8th September 2023. And here it says that para 2, the financial bid was open for all 5 bidders who have qualified the technical bid as mentioned below. The names are mentioned, and the observations are: on opening of the financial bid as uploaded by the above said bidders, it is observed that the status of the quoted amount by the respective contractors is indicated below. And Ballots may see just point number 2, where the petitioner is there, which is a bid of 1 rupee 34 paisa more than the remaining bidders who have quoted at the department's estimated value. That is, at point number 2 is the petitioner's bid, and at point number 3 is the successful bidder's bid.
Yes, got it.
Yes. So, my lords, thereafter your lordship just sees that after there was identical bids by all these bidders, then a meeting is called of all the L1 bidders, and that your lordship will find at page 178 of the appeal paper book. In the interregnum, Milords, I may just indicate one aspect, that on the opening of the financial bids, all the representatives of the bidders were there at that meeting. They were aware as to what is happening, Milords, and the request was made by the petitioner that his bid should also be treated as an identical bid, and the matter should be finally decided on who is providing a better technical specification, irrespective of the financial bid quoted by these bidders. That representation your lordship will find at page 115 of the appeal paper book. 115. So, well, this is 115, your lordship just sees, this is a letter dated 18th October 2023. October, Milords, this is a letter written by the petitioner herein. Says the second paragraph, since the financial bid, the rates quoted are same, hence the selection of the party would have to be done on the technical evaluation of the qualified bidders. So that is the case of the petitioner. The petitioner has no grievance as far as what happened, how these identical bids were quoted. His contention was that the technical evaluation has to be taken into consideration while deciding who would be the successful bidder, which in my humble submission will also is impermissible, because it's a two-stage bidding process, and once parties have been found to be technically qualified, there is no question of falling back again on the technical specifications. After this, my lord, these bidders were called, the L1 bidders were called for a meeting to decide the settlement of the contract, which your lordships will find at page 178. This is a meeting, my lords, dated 7th February 2024. All bidders, all L1 bidders were called at 178. And it says that the chairman highlighted that the matter to the meeting held earlier, decision to select the successful bidder, since all four bidders, i.e. L1 bidders, are qualified and quoted at par in the price paid tabulated below, the names are mentioned. The chairman, after scrutiny of the minutes of meetings, felt that the process of allotment of the work had taken a long time, of which further delay will bring a great loss to the corporation as well as the government in implementing the development schemes. After a threadbare discussion, the member agreed expediting the process of allowing L1 bidders to discuss and come to a mutual understanding among themselves to allow one bidder to execute the above mentioned work. So an opportunity, Milords, first was given to the L1 bidders that you decide amongst yourself whether you want to pursue with the matter or we should select one of you. That is in paragraph 2, Milords, of this letter, of this minutes of meeting.
Very important.
Yes, Milords.
You are Mr. Pandey.
Yes, Milords.
There is a matter fixed at 12:30.
Yes, Milords.
So we shall take it up again tomorrow.
Milords.
Tomorrow, Milord, I am coming from outside, Milord. Yesterday also I was here. If your Lordship fixes some other date, Milord. I understand, Milord, apart from him, Milord, there is another appellant who is also to make the argument. And after that is done, Milord, I can reply together to the submissions advance.
How much time you will take, Mr. Pandey?
Milords, it will take about 20 minutes, Milord.
Let him finish it tomorrow. You join online from wherever you are. But let us not stop him.
Okay.
Yes, Milords.
Lordship, the other appellant, item number 6, Your Lordship, liberty may be given, Your Lordship, to appear through online, Your Lordship. Ms. S. Parveen, Your Lordship, through VC, Your Lordship.
Tomorrow.
Yes, Your Lordship.
All right. Mr. Pandey continues his argument, appearing for so and so, but does not conclude the same. List this appeal for further hearing tomorrow at the top. Mr. Pandey, how many years you have put in at the bar?
Milords, it's 5 years, Milords.
You have argued remarkably well.
Milords. Obliged, Milords.
Item number 3 and 4.
No, for the fixed matter. Other matters are released for the day. Keep this properly. You add there Mr. Dotto and Miss Parveen are allowed to join the hearing online. And before that, we read considering the special circumstances. Yes, Mr. Park.
My lords, may I please, my lords. My lords, we appear in item number 4, my lords. Now, the petitioners before your lordships, my lords, is the Association of Meghalaya Bonded Warehouses. We were the bonded warehouses, my lords, which operated prior to the creation of the central bond.
Yes.
Now, my lords, while adopting the arguments, my lords, which was made by...
And still operating.
Still operating.
But with the central above you.
Yes. My lords. Now, basically what has happened is, my lord, earlier there were 3 layers. There was the distillers or the manufacturers, my lords. Below them we were operating, and from us the retailers were purchasing. And my lords, that was the arrangement continuing. Now what has happened is, between the distillers and the bonders, my lords, there is a new layer created which is called the central bonded warehouse.
Yes.
Now, well, it's our challenge before your lordships is with regard to the insertion of clause 44 in the bonded warehouse rules, my lords. These are the Meghalaya bonded warehouse rules. These are actually the Assam rules, my lords, but they were adopted by the state of Meghalaya. Subsequently, my lords, this insertion has come. Now, there are 2 amendments that were made, my lords. The first amendment, my lords, was insertion of clause 2A, Roman 2A, my lords. My lords would... Page 64. If I may draw your lordship's attention to Annexure 4, page 64 of my writ petition. Page 64, my lords, Annexure 4.
Yes, and this same must be here. Or from your rich, I don't mind from your
My lords have it. My lords, may I draw your lordship's attention to section 2, my lords. It says insertion of new clause 2A in Rule 2. And the effect of that is, my lords, in the principal rules in Rule 2A, after the existing clause 2, the following new clause shall be inserted. Now they say, my lords, central bonded warehouse means a licensed central warehouse where IMFL, beer, wine, BIO, etc. imported on prepayment of excise or ad valorem duty. My lords, may kindly take note of this. It says prepayment of excise or ad valorem duty, import pass fee, or transport passage fee and literage fee are kept for eventual removal to bonded warehouses as provided for in the Meghalaya Bonded Warehouse Rules, the Assam Bonded Warehouse Rules 1965 as adopted by the state Meghalaya and its extant rules. Now, then they say, my lords, there is also the insertion of new rule 44, which says, in the principal rules after the existing rule 43, the following new rule shall be inserted, namely, license for central bonded warehouse shall be granted on the following conditions. Well, and the conditions are laid out. Your lordships have already gone through that in the other connected matter. Well, I'll not take your lordships through that. Now, based on this, my lords, an NIT was thereafter called, my lords, on the 17th of November 2020. First, the bonded warehouse is created, my lords, under this amendment. Then, my lords, there is an NIT that is called. And the typed copy of the NIT, my lords, would find at page 68. Now, my lords, my grievance, if before I go to that, my lords, if my lords kindly turn to page 65. And my lords, if my lords kindly have a look at clause 14.
14. It's 14 is
My lords have it.
the earlier one.
Now it says, my lords, on commencement of the central bonded warehouse, the bonded warehouses shall lift all the liquor from the central bonded warehouse against the import permits issued by the Commissioner of Excise and cease to import directly from the company's bottling plants. Now, under this new regime, my lords, I cannot continue with the existing exercise of, my lords, having to pick up the liquor from the distillers or the manufacturers directly. I have to go through the central bonded warehouse.
Yes.
As I was submitting, my lords, pursuant to that, on 17/11/2020, my lords, an NIT is issued for the central bonded warehouse, and, my lords, pursuant to that, the private respondent is declared successful in the NIT and a license is issued to them at Annexure 7, page 77 of my writ petition.
I've read it with you.
I'll just show two other pages to my lords before we can proceed, my lords. This is the license issued at page 77, my lords. And thereafter at page 84, my lords, there are two letters. One is at page 84. The typed copies are at page 84 and 86. First is dated, my lords, the first communication is dated the 14th of July 2021. So the first, my lord, says, this is for information of all companies, breweries, distillers, bottling plants, etc. that Messrs. So-and-so, 9th Mile, Baridwa, so-and-so has been allowed to supply and support different types of IMFL beer, wine, BIO, etc. to all bonded warehouses in the state.
Which page you are reading?
I'm sorry, my lords, at page 84. I'm sorry. This is the typed copy of, my lords, page 83. And which is a communication, my lords, issued by the Commissioner of Excise, Meghalaya, to the distillers. One of the distillers, my lords, 14th July 2021.
Okay.
My lords have it.
Issue one letter.
If my lords have it, may I just read this, my lords?
And now in the other writ, this Umfulu Central Warehouse challenges creation of a
second bond. So what happens is, my lords, basically, if I may put it so, my lords, the state at some level realizes, my lords, that there has been a serious goof up. Now, to cover up that goof up, my lords, they create a further goof up of trying to create a second bonded warehouse, central bonded warehouse.
All right, Mr. Paul.
My lords, may I just read this? This is for information to all companies, breweries, distillers, bottling plants, etc. that Messrs. Umpulio Central Warehouse at so-and-so has been allowed to supply and support different types of IMFL, beer, wine, BIO, etc.
So this is selection of this warehouse.
My lords. No, and there's a direction further, my lords. Because what I'm harping at, to all bonded warehouses in the state. So because the rules also talk about a designated area, my lords, which may come into play at a subsequent part of this argument, of this hearing. So, my lords, this bonded warehouse is irrespective of the entire state of Meghalaya. That's what I was trying to point out. And at page 86, my lords, this is a letter issued to me, all bonded warehouse in the state, my lords. So this says, my lords, this is to inform that Messrs. So-and-so has been allowed to supply and transport different types of so-and-so to all bonded warehouse in the state with effect from so-and-so. Therefore, henceforth, all import permits for bonded warehouses shall accordingly be issued only from so-and-so with effect from the 26th of July 2021. So, my lords, I am obligated to pick up my stock only from the central bonded warehouse.
Yes.
Now, let's the answer to the creation of, my lords, this central bonded warehouse was filed by the state, my lords, before this honorable court. No, this state. An affidavit was filed in WPC number 186 of 2021. That's item number 3, which my lords have already heard. In our matter, my lords, there is no specific affidavit has come from the state. Now, the two reasons, my lords, which they give in the affidavit. The first, my lords, would find at paragraph 26 at page 13, my lords. I'll just quickly take your lordships through what is there, my lords, and then I can, if your lordships so please, I can take your lordships through the affidavit. My lords, the first reasoning they give is, they say it is a policy decision of the state government aimed towards establishing central bonded warehouses for augmenting the overall efficacy of tax collection and augmenting tax revenues. That's the first reasoning they give.
Reading from the contents of the.
I'm sorry, you're referring to affidavit of the state.
Affidavit of the state in WPC 186 of 2020.
Which one? There are 5 affidavits this week.
The first one. First one.
Dated, affirmed on?
Just a second. (27 September 2021).
Thank you.
Well, this affidavit is in WPC 186 of 2021.
Paragraph?
Paragraph 26 at page 13.
Thank you.
My lords have the affidavit. Well, it says that it is submitted that the impugned amendments to so-and-so is a policy decision of the state government aimed towards establishing a... Page 13, my lords, para 26.
Mr. Paul, tell us in short what they say.
My lords, they say two things. In para 26, they say, my lords, it is for augmenting overall efficiency of tax collection and augmenting tax revenues. And at para 36 at page 16, my lords, which is more relevant for our purposes, it says it is been made, my lords, to check leakage of revenue.
Para 39.
Para 36 at page 16, my lords, 1-6. Well, it's happened.
Para, you said
Para 36, my lords, at page 16. The two paragraphs I'm referring to, my lords, 26 and 36. So in 36, my lords, they say it is been brought into place to check leakage of revenue. And para 26, they say augmentation of revenue. Now, what was the scenario prior to this central bonded warehouse coming into play insofar as revenue is concerned? That is relevant for the purposes of the case of the petitioners before lordships. The initial position was, my lords, that the tax collection was post-paid. In other words, my lords, what happened is we lifted the stocks from the distillers, we supplied it to the retailers. Based on, my lords, the sale, the money would then be paid by the retailers directly to the government. Now, in 2019, my lords, a new regime was introduced by the state government. Now, under the new regime, my lords, there was a random change of how this tax revenue was to be collected. What started is, my lords, the concept of prepayment ad valorem was introduced in 2019. So, essentially what happened is, my lords, at the time of placing the order, I had to prepay the duty. The bonders started prepaying the duty, my lords, for whatever was picked up from the distillers or the manufacturers. And only against prepayment, my lords, certain stocks were given to me. That in turn was then passed on to the retailers. So the point that I'm trying to drive home here is, my lords, the reasoning given in para 16 that this had to be introduced for the purposes of checking leakage in revenue is absolutely misfounded. Because, my lords, even from post 2019, the position was that the money is already paid in advance.
tax is paid in advance.
Yes, my lords. So we were paying the entire amount of revenue in advance, my lords. As against that, we lift stocks and we give it to the retailers and it's sold. So there is no question of leakage of revenue. That had already been taken care of by the 2019 regime. Now, insofar as, my lords, augmentation of revenue is concerned, what they go on to further state, my lords, and let's go back to what fell from my lords also in this. They say that it will be easier to deal with one entity rather than dealing with 45 entities. That's the reasoning that is given before your lordships in the subsequent paragraphs, insofar as augmentation of revenue is concerned.
No, but whatever recitals are there in an act or a statement
My lords.
of those at the beginning of the act, statement of
Objects and reasons, my lords.
Yes, reasons and all that. Can the court go behind that? We can examine the truth.
No, I am not on that, my lords. I am saying that when the challenge has been made before your lordships, there is, my lords, they are bringing in, because at some point, my lords, would also get into the test of proportionality. So when your lordships get into the test of proportionality, the reasoning behind a certain government action, my lords, would...
Your main grievance can be, one of the main grievances can be a fallen commission.
My lords,
Because you have to share the commission with the CWC.
lordships. Earlier, my lords, it ranged anything between, my lords, up to 25%. Anything between 8 to 25 was the margin that we had. Now, my lords, because of the CBW, that margin, my lords, get reduced.
Or the alternative would be raising the price of a bottle.
Lordships, which in turn then would affect the retailer,
Yes.
the ultimate consumer.
Would lower the demand.
Lordship.
For the,
In which event I would again be prejudiced.
yes.
So this same argument also came, my lords, from the distillers, but that same argument also follows insofar as we are concerned. Now, what we are saying, my lords, is that...
And third is that you, bonded warehouse owners, have a feel of the market. You know what to get from which distiller.
Well, there was this bargaining capacity.
And sell it
Absolutely, my
to
lords.
the retailers.
We could push a certain product. If I was getting a better margin of a certain product, well, I can push this. My competitor, who's again another bonded warehouse, can push the product of something else. So what it essentially did, my lords, it had a level playing field for everybody to operate in.
So if say suppose in the Jaintia Hills area,
My lords,
there is a great demand for X brand of liquor.
my lords.
But then, according to the
That
argument
same may
of
not be somewhere else.
Mr. Shah, the CWC may not stock it.
Lodge.
So you have to take Y variety and thereby suffer diminution of sale.
Lordships.
These are three,
Lordships
four
are
arguments.
absolutely valid. That is the sum and substance of, my lords, our
He was
grievance.
talking about free market play and all these things. So
Lordships. Coupled with the fact, my lords, that what was placed before your lordships, that the partners in the, my lords, central bonded warehouse are also bonders themselves, as well as distillers. And there is an admission to that effect before this honorable court on affidavit. They say that they have interests, my lords, upstream and downstream both. That I'll just very quickly point out, my lords, that has been filed in this writ petition, in my writ petition. This is an affidavit filed by them, the private respondent, my lords, in September 2023. They filed it on 14 September 2023.
This is the petitioner's affidavit, right?
Respondent, private respondent.
CBW.
So they admit, my lords, at page 4, paragraph 5B.
13 September.
This is filed in this writ petition. No, sorry. Main matter, 186.
yours is WP 234.
Mine is 234, my lords. This is filed in 186, my lords. My apologies. It's in paragraph, my lords, 5B.
The same affidavit.
No, my lords, this is by the private respondent number 3. My lords, this was a additional affidavit filed, my lords, on 14/9/2023. My lords have it. So they say, my lords, that the deponent states that though the partners of Umpolio Central Bonded Warehouse have upstream and downstream interest in liquor trade, however, such upstream and downstream interests do not in any manner affect the commercial interests of other players in the liquor trade like retail outlets, bonded warehouses of manufacturers or bottlers. So there is an admission, my lords, that they have interest both ways. So therefore, my lords, it is but natural that, my lords, a certain brand, I'm not saying it is, my lords, at this stage because that is not on record, that a certain brand may be pushed, which, my lords, in normal circumstances, had there been a level playing field, my lords, would not have happened, as was existing in the earlier regime.
That's all, Mr. Paul.
Well, it's just one more issue that I must touch on.
And we will take it that you are adopting the arguments of this.
I am not. I said that in the beginning itself.
Adopting and adding these.
Additional, supplementing it. Well, it's now a very interesting thing has happened as what fell from your lordships as well. Now, after orders were passed by this honorable court, my lords, for the state to look into this entire thing, the state initially files an affidavit, my lords, and thereafter a technical committee is set up. Now, the technical committee, my lords, has a meeting on the 26th of October 2023 and 1st November 2023, 1st December 2023. And that report, my lords, was filed before this honorable court by way of an affidavit. Now, that becomes very pertinent for the issue at hand. This is an affidavit which was filed on the 22nd of February 2024.
Yes.
Sworn by one Shibi Chakrabarti Sadhu.
This is CBW affidavit.
No, this is state's affidavit.
State's affidavit. 23rd February 24.
This is in 186.
Yes, yes. These are all in 186. Now, the technical committee, Millets, the minutes of the technical committee is at Annexure 1, page 4 and 5. I'll take your lordship straight to page 5 and a serial number 3, Millets. 3B to be more specific. My lords have it. So, at 3B, Well, it's the technical committee notes that although the preliminary analysis of the demand and supply of goods between BWs and CBW and companies indicated that the demands were met as raised. However, a comparative study could not be taken up as at present here there is only one CBW. To create a more competitive playing field and environment for the benefit of all stakeholders, government may perhaps explore the possibility of an additional CPW. This, in my humble submission, my lords, would be indicative of the fact that the decision to have one CBW was essentially creating a monopoly in respect of the CBW so created.
Yes. We continue tomorrow.
My lords.
When is it fixed? Tomorrow and day after.
Another half an hour?
Max.
12:30. Huh? 12:30.
Even tomorrow, I think it will be.
What are you thinking of? Your son. Mr. Paul, learned senior advocate, appearing for sponsor. Commences his arguments but does not conclude the same. List these appeals tomorrow, as per the schedule at 12:30 p.m. or after exhaustion of the regular list, whichever is earlier.